Ladies and gentlemen and ladies and gents, I don't want to hear it. Yes, I know it's true. I know it's true. Yeah, you know it's true. I'm a genius. Okay, ladies and gentlemen, many people, I was just watching high frequency radio, and they had this man I have a lot of respect for it. Gene Keating! Like I told you, the information I learned was from people like Gene Keating. Although I could never be around Gene Keating or the people Gene Keating was around, the people I was learning from was learning it from the people that he was around, that he was learning from. That's why if you listen to him, he's saying pretty much the same thing I'm saying. Now, I'm not saying that we are cut from the same cloth. We're going to do some just the way you are, okay? Some Barry White, just the way you are, because y'all just got to accept me just the way I is, because I'm perfect all by myself, Anyway, ladies and gentlemen, I was just going over in my mind, if a person goes into court, what would I say if I was called into court tomorrow? Well, although there are a lot of things I could say, the things that would be most important, and it's going to be a minute for Barry White to come on, because it was spinning, y'all. Y'all know the spinner, see it's still spinning? Y'all can't see it spinning, but it's spinning, y'all. And it just ain't caught up with me yet. It says ain't responding. You see? No non-responders. It's supposed to be a first responder, but it is not a first, it's a non-responder. Ladies and gentlemen, if they called me into the court, and the first thing you hear is, all rise. No. Sorry, no, I wouldn't do that. No, actually, I would. No, I will not. Because, now I'm not saying that you were to say, no, I will not. When they say all rise, that's not a sign of respect. That's a sign of submittal to a jurisdiction. Pay attention. Okay? When they say all rise, that's a command. That's not a request. If you are capable, could you please stand? You see, this is the one thing. See, if I'm at a Kingdom Hall of Jehovah's Witnesses, the first thing they say is, let us stand if you are able, or let us stand and offer a word of prayer to Jehovah. If you are capable. Why? Because not everybody's capable of standing. It's not a command. You don't have to. Just like the NBA today, telling their players that they have to stand for the national anthem. Excuse me, where's that in my contract? Where did I agree to do that? The moment you agreed to accept our money? No, I didn't. You better go take another look at that contract. Well, you agreed to go with the players union. The players union said that you need to stand and show honor and respect to the flag. Excuse me? Honor and respect to the flag? That flag ain't never honored and respected me. Okay, ladies and gentlemen, let me tell you what I would do if I was you. If I were me and I'm standing in court. Your Honor, I'm here representing the defendant. Excuse me? Excuse me. Who's the defendant? Your Honor, no, excuse me. I just need to make sure who the defendant is. You see, everybody in here was named by somebody. They spoke up for themselves, but you're the only person who ain't told nobody who you be. So who the defendant is. I think it's you. Let the court record reflect that the person sitting up there in a black robe has now identified themselves as the defendant. I bring forth the presumption. Go ahead and rebut it if you can. I'm not saying that you say those exact words. But remember, they always announce you and that idiot sitting on a bench. So you go ahead and name that idiot as the defendant. Let them prove that they are not the defendant named in the complaint. Okay? Oh, I got a signed affidavit right here. Shows I ain't the defendant that you calling. This is who I am. You understand what I'm saying, people? So, since I ain't the defendant, you people have no jurisdiction over me. I ain't contracted to be here. I don't agree with this. You're trying to hold me as a slave. You're trying to hold me against my will. I don't consent to this bull. Excuse me. I don't consent to this. No, no. You don't get to do that. You don't get to sit up here and say I'm doing this and I'm doing that. I just told you that I'm not the defendant, that you are the defendant. Ain't nobody else in here failed to identify themselves but you. And since the record shows that the defendant is a juristic person, you're the only one in here that's a juristic person. Go ahead and look at your own statutes. You are a juristic person. That's why you can't even speak for yourself. You can only speak on behalf of the court. Ladies and gentlemen, this was only designed to help you understand what's going on. Not designed to tell you what to say, but to tell you, quit assuming that you have to defend that you're not the defendant. It's not whether or not you are the defendant. You don't have to, I ain't no blah, blah, I ain't no, you ain't got to sit up there and do all that. They operate on presumptions. The court operates on presumption of law. So, ladies and gentlemen, kill them with their own presumptions. Yeah, the only thing in here, you guys ain't got no proof of my identity. The only person in here who can identify me is me. I challenge all of that junk you claim is identification. That junk ain't identification. None of that stuff is validated. Do you understand? You are the only proof of who you are. No one can identify you. Did you know your own mama can identify you once you reach the age of 18? She doesn't get to tell me who I am. No. I'm a grown man. I'm the only person who can identify me. You can't identify me with no one-dimensional picture. When was that picture taken? Well, then that ain't me. Do you understand? I'm standing right here. How could that be me and I'm standing here? So get that bull crap out my face. Do you understand? Hey guys, the whole town is laughing right now because they think what I'm saying is foolishness. Ladies and gentlemen, I give you my word that I am not being foolish right now. They have said that you are that person on that paper. And you go in there and they call a name and you answer to it and you go, well, I'm not that person. Excuse me. Does anybody know where the defendant is? Well, the court just called the name. I'm sorry, but that ain't my name. And then you give them your name, last name, then your first name. And they say, are you not the... Excuse me. Let me explain it to you again because you seem to be deaf. I am me. My name is Slim Shady. Hi, my name is... Anyway, and my name is not what you say it is. I just told you what my name is. Do you have any evidence anywhere to rebut what I just said? They can bring out all kind of IDs and everything they want. Excuse me, that's only prima facie evidence. That's not my signature. ID, that's just a picture on a piece of plastic. I wasn't there when that was produced. That's not me. That's a juristic person. Juristic. Okay? Means a legal person. Ladies and gentlemen, stop saying you are not the defendant. You don't have to. Say, excuse me, my name is such a... Where's the defendant at? The defendant? Wait, you're the only person in here who hasn't identified yourself. You have to be the defendant. Wait a minute, wait. Perhaps this is the defendant. I don't know who the defendant is, but I know I'm not nobody's defendant. I know I'm not a defendant. Oh, I'm not here to defend nothing. No, in order for me to defend something, I would have to accept your jurisdiction. I would have to submit to being held in servitude. And I do not submit. I do not consent to this bull crap. Ladies and gentlemen, this is not telling any of you what to say. This is only letting you know that when you're in court, the only person who doesn't identify themselves is the judge. Are you feeling me? So, take that shoe off of your foot. Quit sitting in the role of a defendant. Excuse me? He's here to represent. I'm a grown man. He can't represent me. No. If I was a defendant, if I was a legal person, if I was a juristic person, then maybe he might be able to represent me. Maybe he could call me a client for which he would owe no duty to whatsoever, because his first duty would be to the court and to the public. Okay, so maybe, but I would never have such an idiot speak on my behalf. No, as a grown man, I'm a free man. I don't care about you guys saying living flesh. No. I'm a free man, according to the Constitution. And I just need to know, under the Constitution for this state, where does this venue get its jurisdiction? I did not see anything within the Constitution for this state where this venue has any authority. And no, we're not taking no recess. You don't get to do that. See, when you take a recess, you think that you get to do that. That gives you jurisdiction if you take a recess. That gives you to waive time. You see, the right to have you prove jurisdiction on the record, you must have jurisdiction in the first instance. This is that instance. So where's your jurisdiction? Look, you know how they tell you that the judge gets to lie? The attorneys get to lie? Ladies and gentlemen, they don't get to do that. The judge doesn't get to lie, the attorneys don't get to lie, and the police officers don't get to lie. There is no constitutional amendment that gives them the right to lie. Now, if you notice, it's the same beat for Float On, but this is, oh, honey. Okay, y'all know about this, the delegation. Dum, bum, bum, bum. I love this song, y'all. Okay, they don't get to lie. A statute cannot give them permission to lie. Once they lie, they have perjured themselves. When the police come and show up in a courtroom, and if it is found that they lied to a plaintiff, to a defendant, to a litigant, then their testimony is inadmissible. The lie is admissible as perjury. Why? Because they did it while operating in their public capacity. As a public officer, they cannot lie to the public. They must represent the interests of the public. They cannot lie to the public. And if the individual is there being represented as a defendant, he is a member of the public. These officers cannot lie to the public. They must represent the interests of the public. They must do everything in the interest of the public. It is against public interest for public officials to lie to the public. That means they can't be trusted. So trust me when I say that you take the fact that they lie and you turn it against them. When you are being prosecuted, you bring up the fact. If you were filing an appeal and you had a police officer testify, you bring up the fact that this individual lies knowingly and thinks that there is a law that protects him, that gives him immunity when he does not represent the sovereignty of the state, when in a capacity of a liar. He cannot represent the sovereign and lie. It is not possible. There is no provision in any constitution which permits that. It is only statute that gives them, quote unquote, immunity from lying. He only gets statutory immunity. He does not get immunity from the Constitution. That's why you raise the argument on appeal that he does not have the right to lie and that he was not operating in a lawful capacity. He was acting legally, he just wasn't acting lawfully. Ladies and gentlemen, all I'm giving you is an understanding. Many of you are getting caught up. What they're doing is they're using a technicality. Okay, what's the technicality? You go in court and say, I'm not that person, I'm not that person, I'm not that person, but you have 4 or 5 people saying that you are that person. And you know what you don't ever say? Oh no, I'm me. My name is blah, 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 and I am a free man. I was born free. I'm not a slave and I have not agreed to be here. I'm not under contract with you, and you can't prove or show me anything that says I'm under contract. As a matter of fact, I demand that you produce that contract. Now, ladies and gentlemen, we're going to show you guys something real quick. Let me get this out of the way. Hold on. I just needed to make sure this was covering the whole screen. We're going to open up Microsoft Word. Word? Yeah, Microsoft Word. Word. Okay. Word up. Okay. Oh, honey. Ladies and gentlemen, the song is called Oh, Honey. If you haven't gotten it yet, that's all they say. Oh, honey. All right, we're waiting for my Microsoft Word to pull up. So me and the delegation are going to take a break. One. All right. Now, just want to bring them back, y'all. They were going down and you saved me. When you let me in your loving heart. Yeah. My song, y'all. Now, I'm looking for a particular page. So would y'all be so kind as to bear with me for a moment? I highlighted it, so I'm looking for the highlight. No. See? Pay attention. This is another one. The court must treat all unrefuted allegations as true. They just said you were the defendant. You haven't identified yourself. You only say, no, I'm not the defendant. But you haven't identified yourself. Say, you need to tell them who you be. When no evidentiary hearing is held, you have the right to an evidentiary hearing. On a motion for post-conviction relief, the movant's allegations are accepted as true unless they are conclusively refuted by the record. The appellant has alleged a factually sufficient claim for relief which is not refuted by the record. Now, I've been hearing people talk about, including Gene, talk about how you must do documents and documents have to be done the right way and there's a proper way. No, there isn't. Do you understand that they cannot restrict you or penalize you because you didn't follow their format? I'm a stickler for not following their format. I can't stand their format, ladies and gentlemen. I think the section I'm looking for is right about nearby. Okay, these two paragraphs right here. Now, what I want y'all to do is I want y'all to pay attention. It is impossible to prove jurisdiction exists absent the substantial, meaning necessary, nexus connection with the state. There must be substantial information proving that you are connected with the state, such as voluntary subscription to license, which is why they always introduce a picture of your ID, because that shows that you volunteered and you are licensed. That's why the police officers ask you for a driver's license, because they need to prove that you are licensed with the state. If you are licensed with the state, they can regulate. Regulators, mount up. Okay? So how do you do this? How do you handle this? First of all, every state has a form that you can fill out where you surrender. Surrender. I surrender your ID. Ladies and gentlemen, this is Tevin Campbell. Okay? Tevin Campbell, what's the name of this song? I used to think of you. Come on, this is from the album Yeah, I Know Tevin. Come on now. Come on, Tevin, hurry up. Give me the name. Look, waiting for the name right here. Oh, Perfect World. I met you, such a perfect world. Anyway, ladies and gentlemen, pay attention. They're asking you for your license for a reason. So I'm not going to tell you to do anything other than this. Your problem is you never picked up on it. I don't have a driver's license. I don't want a driver's license. I just have the ID. The ID is not a license. The ID doesn't permit me to do anything. You listen to the word permit? I don't have a permit. I don't need a permit. Okay? You don't need a license to drive. You don't have to suspend it. You don't have to revoke it. But if you got a suspended license, people, if you have a copy of that license, surrender that stupid license to these idiots. There is a form that you can fill out. Every state has a form where you surrender your license. Why do you surrender it? Because you no longer want to be licensed with that state. You don't want to have a contract. I've been trying to tell you guys this for years. Okay, that's the first thing. There needs to be, in order for them to have jurisdiction, you need to have a license. That's why they're always producing pictures. They produce that as evidence. We just showed you the first one, where if you don't refute that, then it stands as fact, because they operate on presumption of law. So let me do this for you. First of all, you have to challenge presumption of law as unconstitutional. See, presumption of law presumes that one can bring up a false claim, and that claim could be taken as fact if nobody argues the claim. But to argue the claim would be submitting to a jurisdiction, wouldn't it? Don't go in there saying that. You just need to understand the understanding. Now pay attention. All jurisdictional facts supporting the claim that supposed jurisdiction exists must appear on the record of the court. So, all rise. The court will now come to order. The Honorable blah, 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 blah. Okay, they just put it on the record, people. And appearing today, appearing means you submitted to the jurisdiction. Go and look up the word appearance. Do you understand this is what they're doing? Read what it says. There cannot be any jurisdiction unless there is a license with the state. With the state, such as a voluntary subscription of license, driver's license. All jurisdictional facts supporting the claim that supposed jurisdiction exists must appear on the record of the court. It's all contract, people. So, resignation of registered agent. Make sure you have a copy with you. Make sure you have your affidavit with you. Make sure your affidavit explains the necessary things. Get rid of all that junk, that extra stuff. You must be a free person. You must have attained the age of majority, because if you're still a minor, they have jurisdiction over you. Now, how do you no longer be a minor? That's what SATCOM is doing for people, making sure they're not documented as minors anymore. All right, let's continue. Well, because a lot of people want to be free. Documents don't make you free, people. Ain't one single document can make you free on the inside. No, I ain't talking about that. There's no document that can make you free. You have to know who you are. So let's continue, shall we? We put it in red for you because we want you to see that. Where a person is not at the time a licensee, neither the agency nor any official has any jurisdiction of said person to consider or make an order. So if you don't have a license, I got to get rid of this right here. This is a period. That period don't belong there. Oh, why you treat me so bad? Y'all know this is Club Nouveau. Now, for those of y'all who don't know Club Nouveau, man, Club Nouveau was the stuff back in the day. And then all of a sudden, they wasn't. Okay? They did that one song, Rumors, and everybody and their grandmama was singing about rumors. How did all these rumors get started? Started with the jealous people, and they get mad for something they had and somebody else is holding. Hey, that was the song. Anyway, let's continue. Ladies and gentlemen, while my computer is, and this is definitely the system messing with my system, and I don't appreciate that. So I'm going to take care of that this weekend. Going to websites and everything is horrifically slow, and it is no virus, but this is what they do, so we're gonna take care of that. Okay, so let's finish talking so that you guys get it. Where the defendant, you, your mama, your daddy, your uncle, your cousin, your sister, your mother, your brother, is not at the time licensed with a driver's license, with a contract with the state, neither the agency, the court, or any official of the court has any jurisdiction over you, the defendant, your mama, your daddy, sister, brother, cousin, uncle, brother, monkey's uncle, all these other people, to consider or make an order. So how can the court operate when they don't have the authority? They do it all the time. That's right. And that's why you got to know what you're supposed to know. If you don't know what you're supposed to know, they're going to keep doing it all the time. One ground as to want of jurisdiction. What does that mean? Want of jurisdiction? Well, look, that's a legal term. Want of jurisdiction is a legal term. It is not three separate words. It's a legal term. Look up want of jurisdiction case law. Just that simple. If the court is in want of jurisdiction, in other words, I want that. Can I have that? No, you can't have that. The court is the one who is asking, can they have it? And the law is saying, no, you can't have it. Because, look, the accused was not licensed or licensee, and it was not claimed that he was. See, if they make a claim, you have to rebut the claim. So when you get a traffic ticket, what do they introduce? Do they not introduce a license? Excuse me, that's not a license. You better take a look at that. That's just a piece of plastic. That's not the contract. I need to see the contract. I need you to produce the contract because I didn't sign that. You better take a look. I did not sign that. Please, look how small that ain't my signature. I don't care. That ain't my signature. I did not sign that. I did not sign anything with a photo next to it. You better go back and re-look at the situation because I certainly didn't sign that. And there is nobody here today that can prove that I did or say that I did. I did not sign that. So what I need you to do is pull up the surveillance of that particular facility and let's see if it was me who signed that because I did not sign that. That is a forgery. That is a legal person. So no, I am not under contract or license with you. That's if you haven't gotten rid of that piece of junk you call a license. Ladies and gentlemen, why isn't everybody else telling you this? Well, they are. A lot of people are mentioning this to you. A lot of people are talking about challenging jurisdiction. A lot of people are talking about they have no jurisdiction. A lot of people are saying you don't have to have a license. Okay, this is what Senator Stump was talking about, people. Okay, these are the facts. But look, if you guys have ever seen the document, do yourselves a favor. You want to pull up the original. Why you treat me so bad? Anyway, this is, you just type this in, absence of jurisdiction and other administrative arguments. Type that into Google. Okay? Just type that into Google. And pull up the original document. Ladies and gentlemen, this is an outline of how the courts work. Step by step of how the courts operate. That's why the first thing they talk about is jurisdiction. Take a look. It is the accepted rule in state court as well as federal court that when a judge is enforcing administrative law, they are described as mere extensions of the administrative agency, which means they operate under the executive branch. They are not judicial. Gene Keaton told you all to go ahead and look at the law that allows the Article 3 court. It is not the United States District Court, it's the District Court of the United States. Let me see. I do need to show this to y'all. Hold on. Let's open it up. I'm just mentioning this because I just need to show you guys. When I write my motions to the court, and I don't follow their format. I don't care about their stupid format. Their format is not my concern. Oh, I went the wrong way to open this. Open. So we're going to have to go... Oh, this is my song. This is Symphony Unknown. This is Maxwell. And if any of y'all has ever, let me say it again, has ever listened to my ringtone for my phone, you know that this is it. Okay? It ain't there, so that ain't it. I need to go to this one. No, that's the one I was just at. Need to go to this one. And then we go here. Oh, it's not here either. All right, hold on, y'all. By the time I come back, the song will be on. So once I's back, looking for this one. There's an ocean, y'all. Drain of all its years. Took a vow. Just can't leave. The Federal District Court of the United States of America, not the United States District Court. I told you when they changed it And I make sure now a freeborn man, etc. all. They got mad at me. They sent back my lawsuit, even though I sent them more than they were supposed to get. They even had the nerve to tell me, and you got to sign the money order. No, I don't have to sign no money order. I don't have to sign no money order. There is no law, no requirement for me to endorse a money order. The money order is endorsed by the one who receives it, not by me. It's not a check, you idiot. That was me leaving a message for the supervisor. Told her, you need to check the law instead of sitting up here trying to quote law to me, giving me legal advice, ignorant mother. I'm sorry. Ladies and gentlemen, I was just pulling it up. It took that long just to show you that I've already known how the courts are set up. I already know the Constitution does not authorize an administrative tribunal. The executive branch does not have the right to create law or enforce law. That's what Congress said they did. They gave to the executive branch the powers of Congress to make and enforce law. That's why they created something called case law. Look, I need to show y'all something. So, dag nabbit. I like this song and I don't want y'all to miss it with me, but we're going to miss it together. Hold on. We're going to pause, my boy. 1 second, Max. And we're going to let this play for a second because I definitely want y'all to hear this. That's if it's going to play. I'm trying to let it play in my...
FW, forwarded message, Monday, April 27, 2015. Legalized slavery, the 13th and 14th Amendment hoax, Judge Anna Von Reitz exposes the fraudulent Congress. Another very detailed post by Judge Anna. Click here for previous essential congressional record, House June 13, 1967 H7161 the 14th Amendment. Equal protection law or tool of usurpation. Mr. Rarick, at the request of Mr. Pryor, was granted permission to extend his remarks at this point in the record and to include extraneous matter. Mr. Rarick. Mr. Speaker, arrogantly ignoring clear-cut expressions in the Constitution of the United States, the declared intent of its drafters notwithstanding. Our unelected federal judges read out prohibitions of the Constitution of the United States by adopting the fuzzy haze of the 14th Amendment to legislate their personal ideas, prejudices, theories, guilt complexes.
We're going to stop right there for just a second. Pay attention to what this speaker, Rarick, said, that the judges, unelected federal judges, read out prohibitions of the Constitution of the United States by adopting fuzzy haze of 14th Amendment to legislate their personal ideas, prejudices, theories, guilt complexes, aims, and whims. Though the cooperation of intellectual educators, we have, or through the cooperation of intellectual educators, excuse me, we have subjected ourselves to accept destructive use and meaning of words and phrases. Because many of these words are not legalese. Many of these words are created by the court, not by Congress. We blindly accept new meanings and change values to alter our traditional thought. We have tolerantly permitted the habitual misuse of words to serve as vehicles to abandon our fundamentals and foundations and goals. Thus, the present use and expressions of the 14th Amendment is a sham. Now look, they highlighted the H71262, serving as a clutch to hoodwink, bamboozle. You've been hoodwinked, you've been bamboozled. And to precipitate a quasi-legal meaning semi-legal, meaning not quite legal, meaning a facade, approach to overthrow the tender balance and protections of limitations found in the Constitution. Now this was in the 1960s, after they had already done this, but this speaker said on the floor exactly what the courts have been doing. Come on now. She ain't talking no more, y'all. We done lost her. I pulled this up because I like what he said about federal judges, because this is what you guys need to know. Now, this original post came from
aims and whims. Through the cooperation of intellectual educators, we have subjected ourselves to accept destructive use and meaning of words and phrases. We blindly accept new meanings and changed values to alter our traditional thoughts. We have tolerantly permitted the habitual misuse of words to serve as a vehicle to abandon our foundations and goals. Thus, the present use and expansion of the 14th Amendment is a sham, H7162, serving as a crutch and hoodwink to precipitate a quasi-legal approach for overthrow of the tender balances and protections of limitation found in the Constitution.
What are
But
those
interestingly enough,
balances?
the 14th Amendment, whether ratified or not, was but the expression of emotional outpouring of public sentiment following the war between our states.
This is a congressman saying whether
its
ratified
obvious
or
purpose
not.
and intent was but to free human beings from ownership as a chattel by other humans. Its aim was no more than to free the slaves. As our politically appointed federal judiciary proceeds down their chosen path of chaotic departure from the people's government by substituting their personal law rationalized under the 14th Amendment, their actions and verbiage brand them and their team as secessionists, rebels with pens instead of guns seeking to destroy our Union. They must be stopped. Public opinion must be aroused. The Union must and shall be preserved. Mr. Speaker, I ask to include in the record, following my remarks, House Concurrent Resolution 208 of the Louisiana Legislature urging this Congress to declare the 14th Amendment illegal. Also, I include in the record an informative and well-annotated treatise on the illegality of the 14th Amendment, the play toy of our secessionist judges, which has been prepared by Judge Lander H. Prez, of Louisiana. The material referred to follows: H. Con. Res. 208A Concurrent Resolution to expose the unconstitutionality of the 14th Amendment to the Constitution of the United States. To interpose the sovereignty of the state of Louisiana against the execution of said amendment in this state, to memorialize the Congress of the United States to repeal its joint resolution of July 28, 1868, declaring that said amendment had been ratified, and to provide for the distribution of certified copies of this resolution. Whereas the purported 14th Amendment to the United States Constitution was never lawfully adopted in accordance with the requirements of the United States Constitution, because 11 states of the Union were deprived of their equal suffrage in the Senate in violation of Article 5. When 11 southern states, including Louisiana, were excluded from deliberation and decision in the adoption of the joint resolution proposing said 14th Amendment. Said resolution was not presented to the President of the United States in order that the same should take effect, as required by Article 1, Section 7. The proposed amendment was not ratified by 3/4 of the states, but to the contrary 15 states of the then 37 states of the Union rejected the proposed 14th Amendment between the dates of its submission to the states by the Secretary of State on June 16, 1866, and March 24, 1868, thereby nullifying said resolution and making it impossible for ratification by the constitutionally required 3/4 of such states. Said Southern which were denied their equal suffrage in the Senate had been recognized by proclamations of the President of the United States to have duly constituted governments with all the powers which belong to free states of the Union. And the legislatures of 7 of said Southern states had ratified the 13th Amendment, which would have failed of ratification but for the ratification of said 7 Southern states, and whereas the Reconstruction Acts of Congress unlawfully overthrew their existing governments, removed their lawfully constituted legislatures by military force and replaced them with rump legislatures which carried out military orders and pretended to ratify the 14th Amendment, and whereas in spite of the fact that the Secretary of State in his first proclamation of July 20, 1868, expressed doubt as to whether 3/4 of the required states had ratified the 14th Amendment. Congress nevertheless adopted a resolution on July 28, 1868, unlawfully declaring that 3/4 of the states had ratified the 14th Amendment and directed the Secretary of State to so proclaim. Said joint resolution of Congress and the resulting proclamation of the Secretary of State included the purported ratifications of the military.
All right. Many people have talked about the fact that the 14th Amendment had not been ratified. This is a legislator of the state of Louisiana who are complaining about the 14th Amendment. Here's the problem with that. What happened is, since the so-called Civil War and the so-called war between the states of that time, Louisiana and the other states who were fighting against the established government, because that's what they were doing, fighting against the established government, didn't have a vote. So Congress is saying 3/4 of the Congress who were legally put in place, who were not involved in insurrection and rebellion, remember 14th Amendment, insurrection and rebellion, they ratified the Constitution. Okay, that's what they're saying. That's what 3/4 of the state is. Louisiana is saying we wanted a voice, and what Congress was saying, well, then you shouldn't have sat up there and fought against your government, is what they're saying. So you shouldn't have been involved in insurrection and rebellion. So technically, the 14th Amendment was ratified. Most people don't get it. They're going to tell me, well, you don't know what you're talking about. I know everything about what I was talking about because I was talking about it. All right, hold on, y'all. I got to put y'all on pause. Okay, we're going to start here. Okay, we're going to start there. And then we're going to just let y'all hear this because I want y'all to hear what they had to say.
FW, forwarded message, legalize slavery.
1 second.
Interesting. Jim.
This was
Monday,
sent to
April
me.
27th, 2015. Oaks, Judge Anavon Wrights exposes the fraudulent Congress. Another.
Now, there are some things in here I don't agree with. I just want you to hear what they said.
Data. The PAC Alliance website is another source of information on this score.
Come on now. It's getting on my nerves, y'all. But like I said, they did something, and it's interfering with the speed of my system.
One point I want to make is that these systems are within the equity or contract law framework, which is under trust law sourced from natural law. Within those superior lawful frameworks, full disclosure of the terms and conditions of a contract is required for it to be binding. If not, then it is a deceptive contract based on coercion and manipulation and is non-binding. However, this fact does not prevent agents of government from claiming otherwise, and our ignorance guarantees compliance. Our duty in this sense is to become aware of the full scope of what our actions have done, and begin to rebut any presumptive agreement with an explicit statement.
Now I want you to pay attention to this.
I have heard some arguments saying that regardless of the fraud, since we acted in a way which implied consent, we are bound to those agreements, i.e. registering to vote, paying taxes, invoking benefits as a corporatized citizen, etc. While our responsibility is unquestionable, the burden of honorable conduct makes any party to such an implied agreement culpable for their deception. As a result, an action must be taken in order to start the reconciliation process. Issuing a notice with the precise nature of the fraud places the burden of culpability back onto the originators of the contract, the trustees of government, the so-called authorities at all levels in society. In this sense, it doesn't matter what we call ourselves so long as we have gained enough knowledge about the various deceptions to rebut a presumption when it is presented to us.
I told you.
The bottom line is a living human being is superior and sovereign under natural law, therefore inherently, and their living testimony of verbal, written, or otherwise,
rebuts any implied
agreement secreted away in UCC code or statute. This is what inalienable rights means. They cannot be taken away, but they can be left unused and remain dormant within us. But our rights are being taken away. You might be saying to yourself, while our rights cannot be removed, they can remain unused by us. This is where free will comes in. The Creator endowed us with prerogatives of free will and sovereignty, which includes being a willing slave by our failure to take action. We must care enough to know about what our
Okay,
rights are so we can take
they
action when
are
someone seeks to
irritating me
convince
now.
us otherwise. Heart, mind, and body.
Come on. Gotta shut her up.
The key, as always, is complete accurate knowledge, and acting within this knowledge by bravely confronting anyone who
Ladies and
claims we are
gentlemen,
beholden to a deceptive agreement. The reason why this can be so.
what you all need to know, first of all, our Creator did not give us sovereignty. He says He's the only sovereignty and He will not share His glory with anyone. Those are His words, not mine. So He did not give us sovereignty. Sovereignty is He who has the right to rule. He never gave us the right to rule over ourselves. That's what Adam decided he wanted to do, which is why we're in the positions we're in now. So if you're going to bring up that Creator and bring up what He gave us and what He didn't give us, He never gave us that. That's the first thing. Ladies and gentlemen, the only reason why I showed this to you is because they were talking about the same thing at the beginning that I was talking about, that you all give in by consent. Come on now. It's moving slow, so y'all just hold on. Y'all just hold on, I say it. All right. Where's that word at? There it is. I have heard some arguments saying that regardless of the fraud, since we acted in a way, where's my mouse? Come on, mousey. In a way which implied consent, we are bound by those agreements. We register to vote. It's not the paying of taxes. The paying of taxes does not make you a quote unquote agreeer to a contract. Okay, you must understand you were required to pay taxes from the very beginning. Pay back Caesar's things to Caesar. You're using their script, using their junk. Okay? Invoking benefits as a corporatized citizen. Excuse me. Ladies and gentlemen, they have put you in no other position. They have taken away everything. Here is the thing that you need to understand. Many of you have been reserving your rights. I reserve my rights. Ladies and gentlemen, if you reserve your rights, they're just sitting over there waiting to be used. Oh, I want to reserve that room over there. Let's see, can I reserve it for 2085? I can? All right, I want to reserve, here's my payment. I'm going to reserve that for 2085. What you mean I can't use it until 2085? What you mean it may not be here? I just paid you. Oh, ain't that about a... Okay, that's what you guys are doing when you reserve your rights. You want to exercise your rights. Just like you want to exercise your own thinking ability. It's exercise. What do you mean by saying exercise? Well, if you go to the gym and you just watch everybody else, then you won't benefit from being there. But if you go to the gym and you actually participate in the activities being performed by everybody else, such as exercising, then you will benefit from it. If you don't exercise your rights, you will not benefit from your rights. Okay? Are you understanding that? You cannot benefit from that which you don't use. You're not going to benefit. Oh, sorry. There is something. That whole thing about the judge, the attorney, not the attorney, but the congressman talking. I got to put that here. I almost forgot. There you go. Ooh, doggy. It was difficult because it's on PDF, and so getting this whole thing here, I had to copy it from the actual document that we just looked at. Because other than that, it wasn't going to put in there. So now I got it. Now I'm going to let it listen later. Let's get back to Maxwell. Maxie, thank you, brother. All right. Ladies and gentlemen, you all know that it's all contract. You all know that it's the 13th Amendment. It's not the 14th Amendment that binds you. It's the original contract in the first place. That's your volunteerism. Remember, they need you to volunteer. When you go into a court building, what is the first thing you see? Do you see a sign warning you? Warning. Danger, Will Robinson. Danger, Will Robinson. The sign warns you. The sign says, hey, what do you think you're doing? Well, what? You can't come in here unless you agree to this. So it tells you no weapons. Now, some of you are going to get stupid and you're going to bring weapons in there. Talking about, I ain't got to listen to that sign. That ain't the point. That is not the point. Okay? What I would do for some of you, especially if you're supposed to be in the court, I need you to do yourself a favor. The moment you walk into that building, you see the officers. Before you go through that metal detector, you ask them to speak to a supervisor. Say, I've spoken with the court and they told me I had to inform you that by my coming in here, I am not consenting to the jurisdiction of this building or any of the officers in this building. That I will not give any of you a problem. I just need to express to you that I am not consenting, since you have warnings on those doors saying that by my coming in here, I'm consenting to everything that's going on in here, and they told me I need to bring this to your attention. Okay? Ladies and gentlemen, let him think whatever he wants to think. Let him say whatever he wants to say. If they want to follow you around, let them follow you around. As long as you've given them the announcement, and if you don't have a witness, it's okay. Because the cameras are going to show you talking to them. And so when the time comes, all you have to do is rebut the presumption. Oh, and by the way, those of you who the court says, shut up, you can't say nothing else, say, no, sorry. As long as you raise a presumption, I get to rebut your presumption. And I don't rebut it by just saying I object. I rebut the presumption. So if you're going to take 10 minutes to open your mouth and close your mouth, then I get the same equal time to rebut the junk that you're saying. And all you're saying is words. So I can sit up here and rebut your stupidity with facts. Because you will not spew a single fact out of your mouth, because you cannot. Pay attention, ladies and gentlemen. All jurisdictional facts supporting the claim that supposed jurisdiction exists must appear on the record. None of the junk they put on the record is fact. None of those papers are fact. None of those papers that have any of those foreign seals on it, because they're all corporate seals, people. The county seal, the Secretary of State seal, all of those seals are corporation seals. They are not official seals of the United States of America. They cannot be, unless it's done by an actual branch of government, congressional and or not legislative, executive, administrative, not administrative officers. No, the executive branch and the executive capacity. Here's the only problem. The executive cannot be a corporation. Wait a minute, we just did this. I just played a perfect world. Tevin, you ain't doing that to me. I don't care who you think you is. Kevin? I'm sorry. I'm kidding. I like Tevin. Tevin, very good singer. All the stuff that he's been in. Wait, how is this playing again? We just played. We supposed to be on shuffling. Y'all ain't shuffling. We just played that. Oh, we ain't played Impossible. We ain't played It's Impossible. Okay, let's get back to this. Ladies and gentlemen, do you know what they can't get rid of? Is this expert right here, known as C.K. Davis. Okay? Or C.K. K.C. Davis. Kansas City! Yeah, C.K. Davis. Or K.C. Davis. I keep saying C.K. I don't know why I want to say C.K. But K.C. Davis, they can't get rid of this. Why? Because in this case, which you won't find, this is one of those cases where they didn't publish it. A judge ceases as a judicial officer because the governing principles of administrative law of the court are prohibited from substituting their evidence. So the courts can't put no evidence into the record. Testimony, the court can't testify. Record, the court can't make a record. The clerks of the court don't get... Oh, I'm sorry. Do you understand? The clerks of the court makes a record on behalf of the court. Okay, and because it's administrative, they only consider that record. Well, what if the court refuses to file your documents? Then you have to object to the clerk's record as not being a true record of the court. They cannot listen to arguments or rationale. They must go according to the dictates of the agency for which they represent. And what is the administrative agency that all the courts represent? The administrative office of the United States courts. The courts are prohibited from substituting their judgment for that of the agency. Judges who become involved in the enforcement of mere statutes, statutes, when they are enforcing statutes, they're enforcement officers. They act as mere clerks of the involved agency. Why? Because they don't sit in as a judge. Hold on, I'm going to explain that. So whenever they're enforcing an ordinance, a statute, a code, they do not sit as a judge. Their supposed court becoming thus a court of limited jurisdiction, because they need to contract people as mere extensions of the involved agency for mere superior viewing purposes. They act as reviewing courts. That's all the appeals courts are. They review the record. That's all they, well, we only need to see the record. It wasn't on the record, then we can't consider it. Okay? That's what the appeals court do. They are ministerial clerks. Okay, let me prove it. When acting to enforce a statute enforcer, law enforcement agents, the judge of a municipal court or any other court is acting as an administrative officer and not in a judicial capacity. Courts in administering or enforcing statutes do not act judicially, but merely administratively. You know what? I did not look up American Law Review 71604. And you know what? Impossible. Impossible. This is New Birth, y'all. And this song right here, when I was a kid, I didn't really like it that much because I couldn't get into it. But now that I'm older, I can get into this song. Anyway, it is basic in our law that an administrative agency must act only within the areas of jurisdiction marked out for it by law. What law allows them to operate as administrative agencies in doing these courts? Contract law, the law of simple contract. Okay? Just that simple. That's it. Nothing else. Contract law. That's why there must be a contract. Let me show it to you. There needs to be a nexus, a connection, such as a voluntary subscription to license, which is an agreement, a contract. Okay, hold on. We're going to go here. Ladies and gentlemen, I gotta admit, I don't know who this is. Wait, is this Alex Cooper? Ladies and gentlemen, I should have known, but again, I'm not a fan of Alice Cooper. He is a very interesting character. But I told you, I'm a music connoisseur. I play everybody. Okay, I don't play his other stuff, you know, the stuff that I don't play his other stuff. Accountable for the people, thesis and memorandum of law. This is the law. This is one that's going to show you about the, merely administratively. Okay, in the United States District Court. Okay, StatCom 911. Okay, and then chapter solutions. I just need the actual code, but we're probably not going to find it. Wait, hold on. Let's do. We're going to look up the American Law Review. Harvard Plan, it says American Law Review. We got 604. This says Harvard Law Review. I don't want Harvard Law Review. I literally said American Law Review. But I don't think I'm going to get that. So if you guys can actually find this case, or not this case, but this section of American Law Review where it talks about the courts acting ministerially, then I would appreciate that. Okay? And if it's June 4th and you haven't sent it, June 4, 2018, don't send it. I don't need it. If it's after June 4th, I will have found it by then. So, I'm sorry. I say that because some of you don't realize that in the videos by June 2nd, I will probably have had like 12 emails and 15 emails and 100 emails, and at least 5 of them will have the actual code, will have the actual section. Okay, so it doesn't mean that you don't have to try. It just means that by the 4th of June, if you haven't found it, I would have found it by myself. All by myself. Okay? I am looking for it, but I don't see it. And I decided to put the whole name because if I didn't, it would just give me the little code, and I don't want the little code. Now look, here's the other thing. The American Law Review, I'm probably not going to find it this way because the American Law Review, do you guys understand? It is copywritten material, so we're probably not going to find it in a search. Okay? Which is the problem. We're going to see it in things like this. This is taken from the very same set of laws. This is taken from the very same set of laws. Okay? So I don't want to look at those because that's not what I'm looking for. That's not going to help. Okay? What I need is the American Law Review in just that section. But as you see, it doesn't appear anymore. You got American Law Review, but it doesn't have the 71 ALR 604. Now, he's going to make her love him. That right there is a feat in itself. Okay. Ladies and gentlemen, it's not giving me anything regarding that American Law Review. And so what I have to do is I have to do this. Now, this video wasn't supposed to be this long, but there's another video I'm supposed to be doing tomorrow. I tried to tell you guys something and show you guys something. I'll show it to you in a minute. Those of you who are worthwhile. Not all of you are worthwhile. I'm sorry. I just have to tell it to you like it is. T-I-Z. Okay? 28. Such case law. Why is that here? Because that's unscribed. Scribed. Okay, let's see. Huh. I thought that there would be more. I thought there would be more, but there isn't. And SATCOM shouldn't have been the second one. I mean, think about it. Look, it says SATCOM. It has the document that I wrote, okay, that I put this in, and here, not there. So we'll go to the blog in a second. Every day. I'm gonna get me. Look out me, cause I'm gonna get me. All right. Thesis of memorandum of law. This is just somebody copying and pasting. This 2013. Okay. The Supreme Court has warned, because what appears to be a lawful command, blah, blah, blah. That's in the laws you did not know exist. A statute is not law. Wait a minute. Nor is code law. Point of fact in law, a concurrent or joint resolution of legislation is not law. House joint resolution. Okay, told you guys, House joint resolution is not the law. It's called the Gold Repeal Act. When you deal with House Joint Resolution 192. All codes, rules, regulations are for government authorities only. Stop doing that, people. There is nothing that says that. All codes, rules, regulations are unconstitutional and lack due process. I promise you this case does not say that. Let's do this. See this case right here? Y'all know this song means a lot. I told y'all we gonna go there. Now we gonna get some of our videos gonna be taken down because y'all see we mixing it up. So we ain't just R&B no more. And so they hate it when we step outside the color boundaries. Okay? But we going there. So we're gonna go here, but I need to talk to you a little bit about fidelity. Okay, no, you know what? We ain't gonna talk about fidelity. We ain't gonna talk about fidelity. I'll keep holding on. We're not gonna talk about fidelity, not yet. We're gonna talk about fidelity later. Okay, we pulled up this case. Here's the case. It is actually a case. Now, let's see. What's the website? I don't know this website, ladies and gentlemen. I don't think I've been here before. maybe I have a while ago. This is the Ninth Circuit Court of Appeals. Hey, he's pro se. Oh, then do you know what happens? I think he used the case law. Let's see. Challenges determination of his workers' compensation, contending that he has been deprived of due process. The district court dismissed his claim for lack of subject matter jurisdiction on the basis that Rodriguez has failed to exhaust available administrative remedies. We reverse and remand. Okay, that's the first thing. Okay, he won. Okay, so let's find out why he won. But it says lacking due process. Now they put quotation marks. You see that? So let's look up lacking due process. Oh, there is no word in this document talking about lacking due process. Okay. Okay, so we got due process. Let's do... Nope, there is no... The word lack doesn't even appear. Ah! He's wasted all his tears. Oh, lack does here. Okay, that there lack does appear. Still lack subject matter jurisdiction. We're looking for... District Court concluded that it lacks subject matter jurisdiction. Here we refer to the inadequacy of the record, not in the sense of the lack of fundamental determination going to the merits of Rodriguez's compensation claim, but rather the sense of lack of facts as to the exactly what process the Secretary has or will afford Rodriguez, the type of hearing, the type of reason for the delay. Okay. Oh, that's it. But nothing in here talking about lacking due process. Okay. Let's do statute. Determining not only from its express language, but also from the structure of the statutory scheme, its objective and legislative history, and the nature of the action involved, blah, blah, blah. But nothing in here about God's law. Wait, let's do that. Because they said God's law. Oh, the word God doesn't appear. Okay, hold on. Let me let y'all see. It's because of the way it's written that I know that the case doesn't say this. It says all codes, rules, regulations are unconstitutional and lack due process. Because remember, all codes, rules, this is a quotation. They're saying it came from this case. That's what you gotta know, that there's no way in the world the court would ever say that. Wait. Hold on. I know this song, y'all. Oh, She's Strange. I just couldn't get the title. It was in my head. All right, let's do this. Okay, hold on. We can go here. The record before us indicates that Rodriguez may have cognizable due process claims. Okay, although a mere allegation of constitutional violation would not be sufficient to avoid the effect of statutory finality provisions. Okay, it says that he has cognizable claims. Rodriguez does not make a actual attack on the constitutionality of the, this is dealing with Federal Employment, whatever act, doesn't matter, don't care, procedures themselves, but instead asserts that the procedures are unconstitutional as applied to him. Given the Secretary's failure to provide a hearing after the suspension of benefits despite Rodriguez's request for one, the Secretary's considerable delay in deciding Rodriguez's claim, we do not find due process challenges insubstantial. That's not saying enough. They're not saying nothing about ordinance, and it's only unconstitutional only appears in this document once. But the individual quotes it and other people will copy it. Okay? Look, we simply conclude that on the basis of the record before us, Rodriguez's due process contentions appear to be more than mere allegations included in the complaint to create jurisdiction where none would exist had he not done that. Okay, fine. And is it going to say had he not done that? Let's see if it does say something to that effect. Be more than just mere allegations included in the complaint created jurisdiction where none would exist otherwise. Okay, you can predict what they're going to say if you've read their junk enough. Okay, but the person, it says, our cases consistently have held that unless statutorily mandated, application for exhaustion doctrine lies on the sound discretion of the district court. That's not actually true because they've already said you do not have to exhaust your administrative remedies anymore. You just got to read the case law. The Supreme Court has already said that an individual does not have to exhaust their administrative remedies. Ladies and gentlemen, workman's comp benefits is an administrative practice, administrative issue. That's why he has to exhaust his administrative remedies. But he's bringing up due process. He doesn't have to exhaust his administrative remedy if government is denying him due process. If a, pay attention, private corporation is denying him due process. It's all about the argument, and you don't want to argue. Sorry, remember the courts can't listen to argue for one. Argument puts you in a position of dishonor, so you don't want to be in dishonor. Ladies and gentlemen, this has been an hour and 11 minutes. We will go ahead and conclude this video. We just wanted to point out to you that if you're going to be before the court, you need to stop consenting. You need to stop agreeing to be a defendant. Okay, you need to stop agreeing to be the person on that paper. You don't say, I'm not that person, because you have not rebutted the presumption. You have to rebut their presumption with some fact. So identify yourself and put the blame on someone else. Say, oh no, I sit here and say that's the defendant sitting right there, the person in the black robe. Let the record reflect that I'm pointing at the person in that black robe who's speaking as if he's a judge. When administrative law says that he can't be a judge when enforcing statutes, I think you're here to enforce statute, which means you're not a judge, which means you're a liar. And because you're lying, you are the only one here who can't be believed. You're a liar. Okay? You say things like that when you know that you got nothing else to lose, people. But other than that, you go back to the beginning of this video and listen to what I say on how I would respond, how I would put the blame where it belongs. Practice your argument. Practice how you're going to respond. Practice what you think their response is going to be. You guys have seen enough court cases. Go on YouTube and look at all the cases where somebody says something stupid and how they trap them. Okay? There you go. And stop this thing about letting your license be suspended. You have to surrender your license. You don't have to surrender the card. You just tell them, give them a notice of lost card. You know how the banks do that lost note thing? So send them a notice that you lost it and I don't want a new one. As a matter of fact, I hereby surrender any and all rights associated with that, and I do not any longer wish to contract with you. Now remember, they don't let you register your automobile unless you have a driver's license. You know that, right? Well, you can be exempt. You don't need a driver's license to have your car documented on the highway. That's their policy, but there is an exemption code. So you have to ask them, what is the exception? They always tell you about these rules. Ask them, what is the exception to the rule? Well, if there's a rule, there's always an exception. Congress always puts in an exception. So what's the exception to the rule? All right, ladies and gentlemen, we have Cameo letting us know about her being strange and about how them like it, how strange she is, because they were strange themselves, wasn't they? All right, have a good day, have a good night, have a good life, have a good time, have a goodbye, have a good one. Adios.